An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Marbury versus Madison, 1803. Our study of Marbury versus Madison begins with the presidential election of 1800. In that race, candidates Thomas Jefferson and Aaron Burr received the same number of electoral votes. This tie threw the election into the House of Representatives, which was still controlled by the outgoing Federalist Party. Ultimately, Jefferson was elected president on the 36th ballot, a mere 2 weeks before Inauguration Day. Before the inauguration, the lame duck Federalist Congress, seeking to preserve its own power, enacted the Judiciary Act of 1801. The act created 42 new judgeships, which Adams filled with Federalist supporters. One of the so-called midnight judges was William Marbury, appointed as a Justice of the Peace. John Marshall had himself been appointed Chief Justice on February 4th, but continued to serve as Adams' Secretary of State. It was in this capacity that Marshall inadvertently failed to deliver Marbury's commission that had been signed by Adams. After his inauguration, Jefferson instructed James Madison, his new Secretary of State, not to deliver Marbury's commission that had been left behind by Marshall. In March 1802, the Congress, now controlled by the Democratic Republicans, repealed the Judiciary Act of 1801 and also eliminated the court's 1802 term. This put the court on notice that it confronted Congress at its own peril. The case begins not in the lower court, when Marbury asked the Supreme Court directly to order James Madison to deliver his commission. Study guide. Should Marshall have even been sitting on a case in which he was so intimately involved? Chief Justice Marshall divides his opinion into 3 parts. First, does Marbury have the right to his commission? The court answers the first question, yes. After President Adams signed Marbury's commission, and then Secretary of State Marshall put the Great Seal of the United States in the document, the appointment was finalized. Delivery, a mere formality, was not necessary. Again, recall that it was Marshall's fault that the commission was never delivered. Second, do the laws of the United States afford him a remedy? Yes. Because the delivery of the commission was a ministerial task, not a political question, the Secretary of State can be so ordered, but that is not the end of the case. Third, can the Supreme Court order James Madison to deliver Marbury's commission? Here the answer is no. Article 3, Section 2 of the Constitution provides that the Supreme Court shall have original jurisdiction in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction. Marshall concludes that Section 13 of the Judiciary Act of 1789, which purports to expand the Supreme Court's original jurisdiction to include the writ of mandamus, is unconstitutional. Only an amendment to the Constitution, and not a mere statute, can modify the Supreme Court's original jurisdiction. The Court observes that an act of the legislature, repugnant to the Constitution, is void. And here the Court asserts the power of judicial review to declare the law void. However, contrary to common misconception, Marshall did not invent the concept of judicial review. It had existed for some time in the Anglo-American tradition, and Alexander Hamilton articulated this philosophy as Publius in Federalist No. 78. Only it was not called the power of judicial review, but the judicial duty to follow the higher law of the Constitution. In one of the most famous jujitsu maneuvers in legal history, Marshall is able to both assert the power of the court to nullify unconstitutional legislation and to avoid the possibility that President Jefferson would ignore an adverse ruling by the court. In the end, Marbury's suit is dismissed for lack of jurisdiction. Study guide. How does he accomplish this?